Hello everyone, welcome to this event, Mental Illness and the Law, as a part of our Victorian Law Week. Hopefully everyone can hear us okay. We're about to get started. I would like to begin by acknowledging the traditional owners of the land that we meet on today, the people of the Kulin Nation, and pay my respects to elders past, present and emerging. My name is Anna Maru and I manage the Court Integrated Services program here at the County Court. We'll talk a little bit more about that program in a minute. We're so glad to be putting on this event for you guys today, as we've had a lot of interest and feedback from students and teachers around the relationship between the justice system and mental illness. Mental illness currently features in the legal studies curriculum. We've had a lot of questions around how we consider sentencing and alternative approaches to sentencing, and we've been informed that it's a particular or popular topic choice for students for their research projects and case studies. A little bit of housekeeping before we go on. Please make sure that you're all on mute throughout the event. However, if you would like to ask a question, we really encourage questions during this session. It's a great opportunity to ask questions to two of our judges directly. So we ask that you do that in the chat box, so please send them through. You'll also have an opportunity to ask the questions yourself. So our administrators will ask you if you would like to ask the question to the judges themselves, and we'll be able to take you off mute so that you can do that. I'm going to hand over now to our two panellists that we have today and give them an opportunity to introduce themselves. We have Judge Dee Sexton and Judge Dawes. Who would like to go first?
I'll go first. Good afternoon. Thank you for joining us today. My name is Sarah Dawes and I'm a County Court Judge. I've worked here for nearly 3 years. Before that, I was a magistrate for about 12 years, and before that I was a barrister and a solicitor for quite a while, so I must have been pretty young when I started. Working in the County Court, we sit in the Melbourne metropolitan region, but we also go and sit out in the regional courts for different times every year. So we're based in Melbourne, but we do work in the regional courts in Victoria. And the area that I work in is criminal law, which is the area that I've primarily worked in throughout my legal career.
Thanks, Sarah. Good afternoon, everyone. My name is David Sexton and I'm also a County Court Judge. I was appointed a judge on the same day as Sarah, in fact, so we're both coming up for our 3-year anniversary as judges of the County Court. Before being a judge, I was a barrister for about 15 years, and then prior to that worked as a solicitor for a similar amount of time. So I've been in the criminal law for many years. I really like being a judge, and I'm really happy to be here talking to you about mental illness in the law, because my background is defence, so that is acting for, as a lawyer, acting for people with a myriad of problems, including mental illness. So it's a really big part of our job at the court, which you'll hear about shortly. So it's great to be here talking to all of you. I can see that there are many, many students online, so welcome.
Thank you so much, Your Honours. I just wanted to let students know, if you would like to turn your cameras on so that we can see you, that we welcome that. We'd love to see your faces on the screen. Otherwise, please keep it on mute. We're all having a look here. We'd love to see your faces as you ask questions or listen in. But I've got some questions here put together that we can just start off to get the conversation going, that I will ask to the judges. But as I mentioned earlier, please write your questions in the chat box and our moderators will send them through to us so that you can ask the judges yourselves. So I have been asked to say, though, a reminder that the panel cannot provide legal advice on or comment on specific cases. So just keep that in mind when you're asking your questions. So over to our panel. Question 1 is, what are the programs at the County Court that support people with mental illness?
So I'll kick off, and I hope Sarah will contribute as well to this answer. But essentially, the best way to answer that question is break it into 2 categories. So the court has programs that support people charged with a criminal offence that have a mental illness, and the court also has programs that can help and assist people who might be the complainant or the victim of a criminal offence. So there's two distinct categories. So firstly, if you're charged with a criminal offence and you come to the county court, it's a pretty serious matter. You must be charged with something fairly serious. We do have a range of programs to assist people in fully participating in the court process. So we have a bail support program, which is called KISP, which is Court Integrated Services Program.
Correct.
It's a relatively new program here at the County Court. Basically, in very short compass, it's a program that provides case management and support for people with a range of issues, including mental illness. So there can be linkages to things like psychologists, psychiatrists, counselling, medication, treatment and the like. So it's a pretty comprehensive bail support program. We also have something else. We like acronyms here at the County Court. We have the MARS program, which is the Mental Health Advice and Response Service.
Correct.
That's also a very new program. And that basically, the simplest way to explain that is, if I'm in court, if there's an accused in court and I have concerns about their mental health then and there, I can essentially get a qualified person to assess them almost immediately and provide me and the parties with a report, an assessment as to what's going on with them. Are they encountering a mental illness such that they can't cope with the proceedings, or special arrangements need to be made for them? So the court has a number of programs for people that are charged with offences. We also have a number of programs that deal, or arrangements that deal with witnesses or victims or complainants. So if you are coming to court and you have a mental illness, it could be a very stressful process for you. It could be very stressful. You may not be able to face being in the same room with a lot of people, including the alleged perpetrator. So we have a range of programs that are in place. Thanks, I've just seen a bigger screen so I can see many more faces now, so thanks for that. But we have lots of things in place, such as a witness can give evidence remotely, excuse me, so the evidence can be pre-recorded, so the person doesn't have to do it live, so to speak. We have support people that can be in the room with a vulnerable witness. We even have a range of toys and relaxation. Toys is the best word, isn't it?
And a dog.
And we have two dogs, don't we?
Two dogs.
Two support dogs, Lucy and Kiki. Is that right? I sometimes wish we had support dogs for us, but we don't. So a vulnerable person can have a lot of things at their fingertips, so to speak, to make it easier for them to give evidence. So there's a lot of things in place at the county court from both ends that try and make people participate fully and equally in the process.
And the good thing about those programs are when you are first charged with offending, everyone who's charged originally goes into the magistrate's court. The bail support programs are available in the magistrate's court, but then if you are committed to stand trial or you are pleading guilty to really serious offences, you will come across to the county court. And that bail support program and mental health support is available throughout the entirety of that period if it's necessary or helpful. The other thing is that at the other end, once someone is found guilty or pleads guilty, then there are assessments available for potential supports that might help a person if they are released from custody or if they remain in the community to address those issues, to try and encourage them to rehabilitate, which is also relevant when considering whether or not they're likely to reoffend and whether the community is going to benefit from them addressing those issues in the community. So the good thing about those support programs is that they are available from the moment someone is charged and remanded in custody or bailed in the magistrate's court all the way through until the case is finished. And at the moment, it does take quite a long time for a case to go from the date of someone being charged up until the end, especially because of COVID, there's been a lot of delays. So people with significant mental health or behavioural problems may need to come and go from those sort of programs or to continue to access treatment if they can throughout that time. So it's quite a new, well, when I say new, it's only in the last, I think, 15 years that this sort of treatment has been made available. But the research shows that people who engage in the treatment do benefit from that, and then that follows on where it's a follow-on effect in the community because they're less likely to reoffend, which is really good in the long run.
Thank you so much. And I just wanted to echo what both of our judges here are saying around the, I guess, specialist programs that we're providing now in the county court. Both the KISP and MARS program are quite new. Programs have been available in lower jurisdictions like the Magistrates Court for some time. So it's really exciting that now we have an opportunity to pilot these programs with individuals that come over to our court, which might have more serious level offending. So both of the judges here today are sitting and working with those pilots. So it's really exciting to have them here and to have their support so that we can test, these types of programs with a cohort that has sort of more serious offending and see in the long run what sort of differences we can make and how that might help with community safety and also for the individuals themselves to rehabilitate. So thank you so much. Question 2 is, what does the court recognise as a mental illness?
So I'll try and answer that question. It's a really good question. I'll give you 2 types of answers. I'll give you the technical answer and then I'll give you the more practical version. So technically, a mental illness is defined in the Mental Health Act to be a medical condition that is characterised by a significant disturbance of thought, mood, perception, or memory. So that's the technical answer. The practical answer, as far as the day-to-day operations of the court, is a bit more complicated. A mental illness, for our purposes, is a significant issue with regards to mental functioning that is connected in some way to the alleged offending or the offending. So it's not enough just to say, oh, look, I'm feeling quite sad today. Maybe I'm feeling anxious. First of all, it's got to have some level of significance and it's got to be relevant. So it's got to have some impact on the crime that is alleged to have occurred. And it can be many, many, many things. There are some really obvious examples, such as schizophrenia is a recognised psychiatric condition. It can cause people to be not connected with reality, to hallucinate visually, and also to hear voices. But there are many, many other examples. Severe depression in an appropriate case can also qualify. So it really depends on the case. And in our courts, all the way up to the Supreme Court, what we have learned is it's not so much the label as the impact. So it's all about what it actually does or its relevance to the offending. So it's actually a really difficult question to answer, but hopefully that's a good start.
And I think with that, in regard to that, what we're talking about here is when you are sentencing someone, you have to take any relevant factors into consideration. And if someone says they have a mental illness, they actually have to have proof that they've got a mental illness. So they need a report from a psychologist or a psychiatrist saying what the illness is and then the effect that it's had on that person, either directly in relation to the offending or just in relation to their cognitive capacity overall, so their mental health overall. So if there's a direct link between someone's mental health issue and the offending, that's something that we need to take into account. And it doesn't matter if it's a temporary mental health issue or a permanent issue, they can both qualify depending on the medical evidence. The other thing is that it has a direct impact into how we manage all the factors that we need to balance when we sentence someone. So we need to look at whether they've got the illness, what the illness is, whether it's directly connected to the offending or whether it's just because someone, not just because, but if they have a lower cognitive capacity or a lower IQ, what their capacity is, and how that is related to the way their thought process works and the offending. So it can be really important for an accused person to identify those issues and then to determine what needs to be done to address them. And if the court can accommodate that sort of rehabilitation in the sentence, that's something that a judge would need to consider when balancing all of the sentencing factors.
And it comes up a lot, would be the other point I would make. So I've been in court every day this week so far, and it's come up in every case that I've had. So it is very, very a common occurrence for an accused's mental illness or problems in that regard to have some relevance to the proceeding. Not every case, but I would say more than half. Would you agree with that, Sarah?
Yeah, a lot.
It's really, really common.
And also you might have a few issues, like you might have anxiety, depression, and low cognitive function, and you don't actually get a percentage evaluation for every issue. What happens is a judge has to look at what those factors are and then overall make an assessment of the relevance of those when considering the nature of the offending and the impact that it's had on the person who's committed the offence. And it's also relevant when you look at someone's criminal history. People with a mental illness might have an ongoing mental illness, and that might be relevant when looking at whether they've got a prior history or not, or whether they haven't. And it's also relevant as to work out whether, for example, schizophrenia, which is a psychiatric illness, someone may have not been taking their medication or may not have been subject to treatment, but the medical evidence might be that once they have that treatment and they engage in medication and management, that they're less likely to reoffend. So that again is also relevant.
Thank you so much. And I'll chime in here, I guess, from my perspective as well. I'm a psychologist that's now working in the court environment. So it's been really interesting for me to sit into sentencing hearings or like bail applications and listen to all the different factors that judges need to take into consideration when they are making their decisions. And as Judge Sexton was saying earlier, it's a very common occurrence. And there's often a lot of different factors that judges need to take into consideration. And it's really interesting to hear how they listen to all the different factors that are impacting that individual and then how they then put their sentencing together. It appears to me to be a very tricky task, but they take it all on board and they do an amazing job of it. So thank you so much to our judges for the first few questions that I've asked. We're now going to hand over to all of you. So this is your opportunity to ask questions directly. I just want to point out a couple of quick things. We can only see at the moment 2 schools that have their video currently on. Oh, there we go. We're getting a few more. So we do encourage you to put your videos on. Stay on mute, but put your videos on so that we can see your faces, especially if you'd like to ask a question. So if you could do that for us now, that would be fantastic. We have already had a couple of schools ask us questions, so I will let my moderators know to unmute you so that you can ask the questions yourself. So do we want to, should I do the questions that we've had sent through first? Because we've had some questions from Beacon Hills College. So I might ask the judges those questions while the schools have an opportunity to put their questions through, so our moderators can let me know what order to bring you guys on the screen in. So the questions that we've had from Beacon Hills College, one second, I'll get them in front of me. Are there any cases that have been mentally challenging for you personally? And if so, how did you manage?
That's a doozy of a question to start
I think
with.
the answer is yes.
Yes.
But I think when you have a job like ours and when you have worked in criminal law for a long time, you need to disassociate yourself from the facts of the case so that you don't take it home with you, because it can be quite distressing. And while we've been talking today about offenders and their mental illness, when we deal with cases, we also have to look at the overall picture, which includes the victims of offending, the effect that the offending has on the victim, and the court is required to take that into account as well. And sometimes it can be really quite harrowing to see what happens and the effect that it has. So we really need to be careful of our own well-being, I think, so that we can continue to objectively make an assessment rather than get caught up in the angst and anxiety that's related to the offending.
I agree. It's very important as a judge to stay somewhat detached, which is a bit of a counterintuitive thing as a person. You can't help but be affected by people. And as Sarah said, we every day have people bearing their lives to us, bearing their souls to us, so to speak, in terms of the physical impacts of crimes on them, the psychological impacts of crimes on them. They might have a marriage that breaks down. They might go into hospital. They might be completely alienated from their family. They might develop really significant, long-lasting mental illness problems. So it can be very difficult, and I'm sure we could probably give examples of that. I think driving cases where someone is seriously injured or dies, that can be extremely traumatic. Lots of physically violent or sex offences can also be difficult to deal with. And as Sarah said, we have to train ourselves to, I call it compartmentalising. It's really trying to leave work at work to a degree.
Yep.
And having a healthy life outside work. But it is a challenge, and it's a challenge that I think if judges don't acknowledge and deal with, it can be a problem. So we're human as well. We're like everyone else.
Mm-hmm. Yeah.
Thank you. Second question from Beacon Hills College. How do you balance sentencing an offender with mental health problems with the rights of the victim?
So in the Sentencing Act, Section 5 of the Act outlines all the factors that you need to take into account when you're sentencing an offender. And one of those considerations is the impact that the offending has had on the victim. And the victim will often make a victim impact statement which discloses the effect of the offending that needs to be taken into account. And that's one of the factors that needs to form part of the overall consideration. And the other things that we need to look at are things like sending a message to the community that the behaviour that has occurred is not appropriate. If a person's been in trouble before, a message directly to the accused offender that they can't continue to act in that way. We need to look at the overall picture of punishment and community protection, whether they're relevant, as well as considering whether rehabilitation is a relevant factor, and look at all those objective factors and then put them into the picture through our own human experience, and then in a way measure up all those things or weigh them all up. So David and I were saying before that when you sentence someone, it's not like you plug in the offence, you plug in the age of the accused, you plug in a couple of other factors and the computer will spit out the sentence for you. It doesn't work that way at all. You have to actually balance all of those factors and in the end come up with your own decision, giving weight to what factors you think need to get more weight and probably some maybe a little bit less weight in each individual case.
That's a really good way to describe it. I wish in a way it was as easy as plugging it in and spitting out a formula, but it can be very challenging when a victim or victims are very much impacted by the offending. Excuse me. And what I usually do is explain in open court that their voices will be heard. I've read the impact statement, and victim impact statements are a really important way for victims to participate in the process. But there are a number of other sentencing factors as well. So it's not just personal to the victim. There's other bigger picture issues such as community protection and general deterrence and things like that. So they're one very important piece of the puzzle, but there are other pieces of the puzzle. It can be challenging to explain that so that victims feel heard and respected, but that's the reality of our job. It's one of the hardest things about our job, really, that we have to take into consideration many factors that are often competing against each other. It's a very difficult process.
Absolutely. Thank you so much. So I can see that a few more of you have put your cameras on, so thank you so much. A couple of you, it looks like your cameras are on, but there's something covering the lens. It might be the little shutter. You might need to open that so we can see you. But other than that, thank you so much. We encourage more of you to put your videos on so that we can see your faces. We do have a couple of other questions that are coming through from schools. Before I read out the schools though, so we can unmute you, I know we've had a couple of students that say that they're a little shy to ask the questions directly. And I just want to encourage you all to please don't be shy, we don't bite. We really want to see your faces and hear your questions directly. So if I can encourage you to give it a go, please do so. But we're going to hand over firstly to Kuira Secondary College.
Hello, can you hear me?
Hi, welcome.
Hello. So first of all, I'd like to thank you guys from the County Court of Victoria for this session today. And we came up with one question from our whole class. And I think it's sort of been answered, but we'd like to talk anyway, so we're going to say it.
Yeah,
so
please go ahead.
Our question was, to what extent is mental illness of an accused person considered when sentencing?
Thank you.
Well, thanks for the question. It's a great question. Mental illness is taken into consideration in a number of ways. So one of the things that we've got to do when we sentence someone is we have to make an assessment as to how responsible someone is for the crime. So if you, because of your mental illness, can't think rationally, you can't logically lay out a choice in front of you, the pros and the cons, and then calmly make a decision as to what you're going to do, thinking about the consequences. If you can't do that because you have a mental illness, and there are mental illnesses that impact on that, then the law says you're not as responsible. You're not, your level of culpability, we call it moral culpability, is not as high. And it's really a question of fairness, really, when you're comparing different people. The notion of individualised justice, so you're taking into consideration the person in front of you. If they've got a condition which means, hey, look, they can't really think this through because of the difficulties that are going on with their psychological functioning, then it's not as serious. They're not as culpable. So that's one of the very important sentencing factors that we need to take into account. There are others as well. Sarah, do you want to talk about any of the deterrents?
Yeah, I think also when it comes to the level of punishment, and denunciation means for the community to say, well, we're not going to stand for this sort of behaviour. So if your moral culpability, which really means your personal capacity to understand what you've done and the way you have acted, if your level of moral culpability is lower, then the community would not expect that person to be punished in the same way as they would for someone who has an ordinary IQ or an ordinary level of no mental health issues. So all of that needs to be weighed up, and we need to make an assessment of what the issue is, whether it's directly related to the offending or whether it's just an overall reduction in their moral culpability, and then that needs to be taken into account when you think about how is the best way to factor all of that into what is the appropriate sentence. And sometimes if an offence is serious but not incredibly serious, and if someone has a significant mental illness, then you might consider getting someone assessed for a community corrections order as a part or as the whole sentence, rather than a jail sentence. So sometimes it can also have an impact on whether someone actually goes to jail, whether it's a young offender, whether they go into a youth justice facility, or whether they actually get a corrections order.
It can even impact on a consideration of what might happen to their mental illness in jail. So we are allowed to take that into account, as we should. If there's evidence before us that because of their mental illness, their condition may deteriorate with a term of imprisonment, then we may impose a shorter term of imprisonment, or maybe not impose imprisonment at all. So it's kind of relevant in many, many different ways in terms of sentencing.
And also someone with a mental illness might find it a lot harder to be locked up in custody than someone that doesn't have a mental illness. So you need to take that into account in whether you're going to give them a term of imprisonment, and if so, how long.
It's getting better now, but in jail at the moment, or until recently, because of COVID, there were no visits, no personal visits allowed for many, many months. So imagine that for a moment, if you weren't able to see your family or your partner, and you were trying to rely on that sort of support to get through. And then imagine the extra layer of difficulty if you suffer from a mental illness. It can be. So they're the sorts, that's an example of how we might take it.
Yeah, and also things like when you're first locked up at the moment, you go into a 14-day isolation for quarantine, and that doesn't matter who you are, that happens to every single person that goes into custody. So that's a fairly significant and fairly stressful experience, especially for someone with a mental illness. So all of that we need to factor in working out how to sentence and what to sentence. So I hope that's answered your question.
Good question.
Good one.
No, that was a great question and very comprehensively answered. Thank you so much. So we now have a couple of other questions from Templestowe College, but they've asked me to read them out for them. These are actually really interesting questions, so I think you'll like them.
Making me nervous.
Yeah, they're a little bit, no, they're good questions. So the first one is, do you think people develop mental health problems from their interaction with the criminal justice system?
That's a really hard
That's
question
really hard.
to
I'm not
answer.
sure that we can necessarily answer that. My answer would be perhaps, sometimes, perhaps.
Yeah.
But I think we'd need some expert opinion.
Yeah. The other thing is that sometimes people grow up in a fairly socially deprived or unhappy family environment or social or cultural environment, and that might be relevant for what happens if they are then become associated with the criminal justice system. Their background might have an impact in combination with the criminal justice system, may end up leading to exacerbating or in fact developing a mental illness. But it's pretty hard to answer that because everyone is an individual and some people manage things a lot better than other people.
I think contact with the criminal justice system could definitely exacerbate a mental illness. So if you have a pre-existing condition, it can certainly be made worse by being incarcerated, for example. And I suppose there might be examples of where, I mean, prison is it's not necessarily an easy environment, and I've come across cases where people have suffered injuries in jail, head injuries in jail, and that has had consequences for their behaviour and level of functioning. So perhaps is the answer.
Yeah. Then sometimes people have also mental illness where they need guidance, and when they go into custody, because everything is set up for them, it's actually in a way easier for them to manage their lives in custody because everything's provided. They've got food, accommodation, routine. So that part of the custody is not as difficult, but then being in custody and being a vulnerable person could make other parts of it a lot harder.
We often get reports from experts saying, sadly, they're doing well in custody. And I say sadly because it shouldn't be that shouldn't be the case, really, but it is for the reasons that Sarah's just explained. Some people get diagnosed for the first time with a mental illness in custody.
Thank you so much. I was just going to add to that. I think coming into court in general is distressing for a lot of people, just because there's a lot of unknowns. Sometimes, the cases, as our judges outlined, it can take a long time to work through the different hearings. So it would be hard for us to know, I guess, whether or not being a part of the justice system actually caused mental illness as such. But I would say as humans, if you haven't been involved in the justice system before, anytime you're coming into this sort of environment, it would be distressing. But as Judge outlined earlier, there are a lot of supports in place in the court to support individuals being a part of the court process. And we have different support services for victims and for court users themselves to support with some of that along the way, outlining some of the programs we talked about earlier. So great question. It was a good thought-provoking one. Another question from Templestowe. Sorry, I'm just reading them live. What are the most common mental health concerns that you see in court? And do you think that people are ending up in court because the mental health system is failing?
Wow, these are good questions.
Yeah, they're tough
Templestowe
questions.
High, is it?
Yes,
Templestowe High.
Templestowe
Goodness me.
College.
Templestowe College. The most common, what was the first part? The most common mental health
Yeah,
issues.
what are the most common mental we see in court?
Schizophrenia is very common,
Yes.
and those types of other types of mood disorders. What else do you count?
Attention deficit
ADHD.
hyperactivity disorder, ADHD, that's not uncommon. Drug and alcohol issues caused by mental health issues can also follow. And sometimes the drug and alcohol issues just actually exacerbate the other mental health issues like anxiety and depression are not uncommon, but the level of anxiety and depression is really the most important thing here.
It's got to be significant.
Yeah.
We spend a lot of time, I think, trying to unscramble the egg on the topic of drugs. Do you take drugs because you've got a mental illness, or do you have a mental illness because you took drugs?
Yeah.
So it's a question of trying to figure out which came first or which is the causative factor, because it goes without saying, but I'll say drugs are a huge, huge problem in the courts, and it very much is a significant causative factor in terms of offending. And there's usually or often a link between drugs and mental health.
Yeah.
So we spend a lot of time dealing with that, don't we?
Yeah. And it's often very hard to work out which one came first.
What was the second part?
And the second part was, do you think people are ending up in court because the mental health system is failing?
Well, certainly at the other end of the spectrum, when you, if you've got a mental impairment, people who are sentenced to detention, if with a significant mental impairment, can go to a hospital called Thomas Embley Hospital, which is a hospital that is also a jail for people with serious mental impairments. There is not a lot of room in that hospital, and a lot of people are in adult custodial environments waiting to get into the Thomas Embley so that they can access treatment. So I think at that end, there is a need to expand in that regard. I think in the community, I can't really comment on the level of services available in the community because that's not really we don't really deal with people in the community who access treatment because often people do access treatment and they don't come to the attention of the courts. Other times people have access to treatment, but they choose not to engage with the treatment. And then if that causes trouble, then they will come to our attention.
I think there are resourcing issues. I'd probably go that far and say, from my experience, both as a judge and previously as a defence lawyer, that, for example, in the youth space, I used to do a lot of work with young offenders. And my experience then was that there just wasn't enough resourcing in that space for mental health interventions at that critical stage. And I think also in court, when we sentence people to, Sarah's mentioned a community correction order, we can attach conditions to that, which can include mental health conditions. And sometimes I find that the resourcing behind those services is inadequate as well. So I think, like a lot of things in life, more money is needed. More resources are needed. It's a really big issue. Mental illness is, lots of people that we all know suffer from a mental illness, and it can be very resource intensive.
Yeah. And often people are afraid to engage with services in the community when they probably should. And sometimes through programs that we have like KISP, they actually have their first time where they actually engage with services to deal with those issues. And that's a positive outcome from something that unfortunately has occurred, but it's actually a step forward for those people. But they perhaps have been afraid or not able to engage before it all happened and before they had that help.
I think the legal system in Victoria is getting a lot better. It is a lot better than it used to be in terms of treatments and supports for people with mental illnesses. It has had a very significant stigma attached to it. I think we're getting a lot better at digging down as to what makes people do the things that they do and how can we accommodate that.
Thank you. So we do have another school that would like to come on at screen and ask a question. Now that's Mount Waverley Secondary College. We'll wait for you guys to come on and say hi.
Can you hear me?
We can. Hello
Oh, great.
and welcome.
Yeah, hello. Yeah, I was just wondering. I was wondering to what extent there's like addiction to, like, for example, drugs, alcohol, even like gambling. To what extent that's considered a mental illness, and like what effect that can have on the cases you face.
Thank you so much.
That's a really good question.
Yeah.
I'll start it, but I don't think I can give a complete answer. Substance use disorder is a recognised disorder in a big fat book called the DSM-5. I think it's called, is that right? So it's a diagnostic manual for psychological and psychiatric disorders. So it is a recognised disorder. To what extent it is taken into account in the criminal justice system is really, I think, really complicated. And there's a lot of cases that have come before today in the court system that essentially say, look, if you've offended basically because of a drug addiction, that's not really a mitigating factor. In fact, it can sometimes be an aggravating factor in terms of your level of responsibility. Mm-hmm. But it comes back to that topic I mentioned before of trying to unscramble the egg. And I think it is always relevant because, I don't know, my personal opinion is that people don't just choose to go out and take drugs. There's usually a reason that they do it. And the reason often involves mental illness. So they're inextricably linked, in my opinion.
Yeah.
What do you think?
And things like gambling can be highly addictive. And I think one of the relevant factors there is if someone does have that sort of addiction, what is the link between what they've done and their addiction? And it's not necessarily a mitigating factor, but on the other hand, it might be something that can be addressed. And if they're able to deal with those issues, then their prognosis or their capacity to rehabilitate is improved. And so that would lead to either a longer period on parole or a type of rehabilitation type disposition, especially for young offenders. So when sentencing, if you're sentencing someone who's a young offender, the prospect of rehabilitation and their future is a more significant sentencing consideration overall, most times, than it is for an older person. So if you've got an addiction and you're able to deal with that, then the prospect of rehabilitation is relevant, and it certainly still factors into the sentencing process overall, although it's not always a mitigating factor. Does that help?
Yeah, that's good. Thanks.
Okay, thanks.
That was a hard question.
Yeah, it is hard.
That was a hard question. So thank you so much. I just encourage you, I'm going to ask one more question from my end that we have, but we've probably got time for one more question from the schools. So if anybody wants to send anything through, this would be your opportunity before we finish up for today. But you did mention earlier, Judge Sexton, that things look a little bit different now in the courts with how we manage mental illness. I'm really curious about what are those changes? What's changed?
I think there's much more of a focus on something called therapeutic justice in the last few years. So the courts have started to recognise, for a range of reasons, that it's really important to dig down and try and figure out what makes people commit crimes. And what services can we offer? So the things that we've been talking about today, so KISP, the Mars program, I don't have a program.
Well, specifically the Koori Court, which isn't just a program, but it's engaging with Koori or people within the Koori community and with elders in the community, and trying to engage with offenders who have an Aboriginal background so that they can engage better with the court service, so that they can understand the process and perhaps engage a little bit more so that it's a more productive process, because in the past it's been found to be difficult for people of an Aboriginal background to deal with it perhaps more so than people from other backgrounds.
And we have, starting next week, we have a drug and alcohol treatment court that's starting up at the county court for the very first time. So there are many different ways within which the court is recognising difference and is recognising the deeper issues that lay behind offending. So I think that's why I think we're getting a lot better at it. And it will take time, but I think it's a good thing. It reflects the broader community.
Absolutely. And from my perspective, implementing the KISS pilot here at the county court, it's really exciting to see the judges be really energised and excited about partaking in these types of programs, even though we probably they probably feel like we give them a bit of a hard time sometimes. In saying that, it's really nice to have judges that are really interested in what Judge Sexton, you were saying, therapeutic justice, or we also call that therapeutic jurisprudence. I know that's a big word, but it's something that we take into consideration in the Specialist Courts Division of the County Court. So it's great to see that now we have these initiatives and we can give them a go and try and support people that do have a number of different issues that are finding themselves in the court. So we have the mental services that support people with mental health issues, but as Judge Sexton outlined, we have the drug and alcohol treatment court that's beginning next week, the Koori Court. There are lots of different options, and over the road at the Magistrates Court there are other programs as well for lower level offending. So over time we're seeing a lot more of these programs become available, and we're able to provide different levels of support and different alternative options, I guess, around sentencing, whereas, you know, previously it might have only been jail was the only option, or a corrections order. We're now able to have something that's called, see in the KISS program, a deferral of sentence, for example, where the judge is able to defer the sentence for a period of time and allow the individual to participate in treatment services, and then they get reports from those treatment services, and then that helps them with their sentencing decision. So it gives a bit of a break, say a 6-month break between their sentencing decision, so that they do have an opportunity to participate in support services. So it's lots of different things happening in this space, and it's really dynamic at the moment. So it's something that, you know, to keep your eye on, I guess, because there's lots changing in the court space around us being able to provide different sorts of supports for individuals. Looks like we have one more question. We'll let that come on live.
Hi.
Hi, Vicky. How are you?
I'm good. How are you?
Great. What is your question for us?
So my question is, what steps are taken to educate lawyers of the effect of mental illness and what, like, the consequences that has on offenders' behaviors? Because obviously we help people with mental illness with their behavior, but what do we do to educate lawyers that have to deal with those, you know, with those people?
Great question.
That's a really great question. Thanks, Vicky. I think we can probably only speak for the court.
Yeah.
And within the court, we are very committed to training judges and all staff within the building, really, in relation to all aspects of mental illness, mental health, the allied services that are available. So by way of example, Sarah and I, along with the other judges, spent all day Friday just gone in a training session. It wasn't necessarily about mental illness, but it was about a range of issues, and we regularly have those. So certainly at the county court, there's an ongoing commitment to learning and training and upskilling, because I'm not a psychologist, I'm not a psychiatrist, so we need to learn as much as we can. Previously, as a barrister, I know that there were compulsory ongoing education events, which included things like the programs that are now being offered. And so there's, I think, again, that's another way in which the legal system's getting a lot better.
Yeah, I think when I was a barrister, there were professional development days where you have to attend a certain number of hours per year, and training in that regard. So education in that regard does form part of that service, and it's a mandatory thing that you need to engage in. So hopefully the awareness is raising in the legal community overall.
Fantastic. Thank you so much. Looks like we've gotten to the end of our question time. I wanted to thank all of you for participating today and for some really great questions. There are a couple that really got us thinking. So thank you so much for that. I really wanted to thank our panel members, Judge Sexton and Judge Dawes, for their amazing contributions today and offering their time in a very busy work environment to come and speak with you all. So thank you so much for that. We also wanted to put a special shout out. We have a university that's joined us today, the Russian State University of Justice. We're aware that it must be very early over there, so we just wanted to say thank you so much for joining us, and we really hope that the discussion has been fruitful for you and that you got something out of it.
See you. Thank you.
Bye.
Bye.
Bye.